Members, we're going to call this meeting to order. I'm going to start with a technical change. Staff requested that we really follow the 832 with amendments, because if not, the staff is just not going to be able to track where is that we're going. And we already did that. We kind of made it's not a mistake, but we have to correct the technicality. Senator Clausen moved that we replace and by or, I think it was, and that was 9.1.3, right, in the 810, and then that has to be incorporated into 2.13, right? Could you help me? Sorry.
Madam Chair, members, on the 831 that was adopted, the change was on line 1, or page 1, line 30, and on the 832, which we need to work from, which is a delete all, it engrosses the 831 into the our second unofficial engrossment of House File 826. The change is on page 2, line 18, where you delete and insert or.
Okay. So members, we're going to work out of the adopted amendment 832, just so that we can track the amendments in the correct order. Okay, is that clear to everyone? So we're going to make that correction, and Senator Clausen moves that we adopt that correction on line 218, so we have a correct amendment in front of us. All of those in favor signify by saying aye.
Aye. Aye.
Those opposed say no. The amendment is adopted. Okay, members, I would like to make sure that we have, so this is how I would like to proceed. First, I would like to make sure that we take care of members' concerns and their amendments before we proceed to hear testimony. So I don't want to run out of time, and I want to make sure that we take care of you. So I would like to ask that members proceed with their amendments. Are there any amendments to the bill? Senator Thompson.
Actually, Madam Chair, I wanted to address another matter briefly, and that was you had indicated in today's earlier hearing that when the Republicans were in the majority and Senator Jen Olson was the chair, that notices were not sent. You made it sound as though it was quite rare. And so we did a little digging back in the archives, and I just wanted to give a few examples of the notice that was given for hearings. January 12, 2011, notice given for a January 18th hearing. So 6 days.
Senator Thompson, my apology for interrupting. We can use that time to hear you talk about that issue, or we can hear testimony from the audience that was invited to come tonight. Is your choice.
Well, Madam Chair, I think that this won't take long. I think it's quite an accusation to disparage our majority for not providing notice as an excuse for this committee not providing notice on such a key bill. Now you can see there are far fewer people here than there were for the afternoon hearing. And I think that to make those claims when it seems to me they're not justified, as I go through, I won't give the examples if you don't want me to. I've got 9 of them here. Senator Nino never purges his emails, so we could give you many more examples. I just wanted to point out that it is not protocol. It is not protocol for the committees to not provide notice as required by the Senate rules. And that's fine that we're doing it differently now, but I think to say that this is how it has been done in the past when I can show you that it isn't fair. But if you don't want to hear it, that's fine.
Thank you, Senator. I will compare notes with you, because I actually asked the staff to pull those. And for the audience, we have policy people who care very deeply about the process. So we do keep information, and we have that information available. So we could compare notes. I will be happy to do that. But I do want to give the public the chance. So I'm going to move to make absolutely sure that we take care of the amendments as you requested that we do, so that we use the time to really hear your concerns and your input on this bill. So I would like to proceed to entertain the amendments of either minority or majority members, starting right now.
Madam Chair, do you have 839?
While we distribute the amendments, I just want to let the audience know so that you're not disappointed. We will be here until 8 p.m. Staff, how many amendments do we have to entertain? How many amendments will be? We have a total of 12 amendments that we're going to have, that we're going to debate during the next time. So I'm going to try to do the best I can to get your testimony, but we have to take care of these first.
Madam Chair.
Senator Chamberlain, on your A39 amendment.
Thank you, Madam Chair. 839, page 2, line 1, delete the non-public home and school student language and insert a school-aged child. What we're trying to do here is make very clear to anybody who reads this that there is no intention now or ever to try to bring non-public schools into the realm of this legislation. They're private schools, and they're private for a reason, and we just want to make sure that that stays that way. So I'd like to move that we strike that language, page 2, line 1, and just insert all a school-aged child. I think that would cover intent of this piece here.
Senator Dibble?
Thank you, Madam Chair. I just ask Council, it would appear that this would simply have the same effect. I don't have any objection on first glance, but Council could help me discern the same effect as what we're trying to accomplish with the paragraph D starting with 1.
We're going to give the staff a little time to. Are you ready? Ms. Butler?
Madam Chair, members, I guess the language that Senator Chamberlain proposed would perhaps, I think, bring in a school-aged child if they weren't in school. If they weren't, but it doesn't exclude them, I suppose, if it's, if they're a non-public or a homeschool. It would bring in a chance that there's a kid that's not, a school-aged child that's not attending.
Madam Chair, I think
Anytime school.
this amendment is fine.
Thank you.
Madam Chair, I just want to ask.
Excuse me, Senator. Yeah, I want a clarification as well. So this will include all student, Senator, Ms. Butler, go ahead.
And I should add, this is qualifying, you have to read the rest of the sentence.
Yeah.
It's a school-aged child with that change who voluntarily participates in a public school activity. So it's bringing, they have to already, or they have to have the step of voluntarily participating in a public school activity be brought in. If you look at page 1, lines 30 and 33, it's where non-public schools within their school programs don't have to have or comply with this language that's in the bill.
As well,
Thank you. Senator Dibble.
Madam Chair, we exclude the privates on line 2.8 and 2.9 by how we define school or public school. But I understand Senator Chamberlain's, well, I don't agree with Senator Chamberlain's concern, but nevertheless, this, I think this language would have the same effect as we had originally intended in paragraph D, proposed language change.
Senator Johnson, do you have a question?
Okay.
Senator Franzen.
Thank you, Madam Chair. I don't think it has the same intent or language, so I just want to be clear what this language would change and what's the intent, excuse me, from Senator Chamberlain, because the way I read it, it's not the same thing. It just opens it up more of who would be excluded.
Well, Madam Chair and Senator Franzen, the intent of this, I think part of the intent of this bill is to, anybody who's on school, parts of this bill to address anybody who's on school property, a school event. It's an all-inclusive sort of thing. So the intent of this amendment, if we say a school-age child, we still get to that point, but we just want to make sure that in this particular paragraph, that non-public school is not somehow dragged into this. I know how, you're an attorney, correct? So I know how people can read these statutes and read language, and if a comma changes, something changes and they can find a way around it. So we're just trying, the intent is to get to the same place that Senator Dibble wants to go with this, but to just make it very clear, we're talking about school-age children and not public school, non-public schools or private schools. Just trying to separate that out. And I know it's referenced on page 1, and it says, in page 1, it just says they're encouraged to electronically transmit to the commissioner. You know, we'll address that later, but that's the intent. Keep it very clear that the non-public schools, private schools are not in any way, shape, or form attributed to this bill. And I think the language still achieves the intent that Senator Dibble wants. If you're on the property, you're subject to this law.
Its protections and its requirements.
Senator Nino?
Thank you, Madam Chair. I actually think this is a win-win amendment. Senator Chamberlain, whether you think he has a legitimate concern or not, can allay that concern. And Senator Dibble, I think arguably under the previous language, you could have some 5- and 6-year-olds not yet enrolled in school or dropout former students who are not students participating in extracurricular, co-curricular, or summer programs or whatever. This clearly would include them. Arguably under the previous language, they would not because they weren't students.
Okay, so members, Senator Franson, do you have any other questions or?
No, I appreciate the
Any other
clarification.
feedback?
Thank you, Madam Chair.
And I think if the senators are in agreement, I think the staff's interpretation is correct with respect to the intention that both the author of the amendment as well as the author of the bill actually want to pursue. So all of those in favor of the 839 amendment signify by saying aye. Aye. Those opposed say no. The amendment is adopted. Any other amendments? Senator Nino.
Madam Chair, Senator Dibble, we had this conversation last time the bill was before the committee, and I didn't prevail, so I don't know if I will this time or not. But, Madam Chair, I'm just going to move to strike Section 1, the legislative purpose and intent. It's just simply bad legislative form. This is one of the pet peeves of former Senator Denny Frederickson. Bills would sometimes, if he wasn't on the committee, they came through, they'd get to the floor, and he would have that amendment ready to strike that out because it just really isn't what we do. You kind of alluded to that, Senator Dibble, earlier, so I'm just going to...
Senator Nino, if you, we're going to distribute the amendment, so it is prepared,
You can if you want, but it's pretty straightforward.
just so that people see what, I think is pretty clear what Senator Nino's trying to do, but just for process, we're going to distribute the amendment, and so that we have a number in front of us.
Chair,
Senator Dibble.
anticipated the amendments. Sure you did. And I understand that, and there are members on our side who don't like legislative purposes and intents. I don't have that, obviously don't have that strength of feeling. I understand why people don't necessarily like them. In this instance, I think it's important to retain this language. It came with the strong advice of Solicitor General, now the Attorney General's office, so that should there be some proceeding in a different branch of government, third branch, it is very, very clear exactly what we're trying to accomplish and achieve, consistent with court precedent and kind of established law and common law, et cetera. So in this instance, and frankly, I think it gives good guidance to folks who are looking at this legislation themselves for the purpose of implementing the law, but it also, I think, provides just a sense of clarity should there be a challenge in court that it's seeking to achieve what are established protocols, precedent in law. Some of this language is, language of art that turns on, the infamous Tinker decision. And so it's pretty important to retain this language.
Thank you, Senator. Senators, any comments or any questions for either Senator Nino or Senator Dibble? So on the A33 amendment, all of those in favor signify by saying aye.
Aye.
Those opposed say no.
No.
The amendment is not adopted. Any other amendments? Ready? Senator Nino.
Yeah, let me find the right number here. The A35.
A35 amendment. Senator Nino.
Thank you, Madam Chair. This removes some language at the end of the bill that gives the commissioner the authority to withhold school funding. There's any number of reasons why that's problematic. There are some vagaries in the bill that still exist, even though some things have been tightened up. There is no, at least not in this new legislation, there's no outlined procedure for appeals. It is solely up to the discretion of the commissioner. We can have dramatic changes. Well, we have a gubernatorial election coming up. We could have a new governor and a new education commissioner. We could have dramatic changes in what their definition is for compliance with this. I just think that this is not a good policy to, particularly with a brand new piece of legislation that apparently there's enough concern about what really the intent of the written languages in the actual legal applicable part of the bill that we need to retain the legislative intent clause. And so at bare minimum, if we were going to do this, I think it should be once this is fully settled into place. I'm not sure that that's even a good idea at that point as well, but that is the purpose of the amendment, Madam Chair.
This is where they put it in. Oh, so if the commissioner starts here, the commissioner can't redo this.
Thank you, Senator. It's interesting, Senator Dibble, you don't serve in this committee, but we are talking very seriously about moving in this direction in education in many areas, and I think we have bipartisan support, because I am quite disappointed that we keep giving money to schools that we don't know whether the money is being used for the actual policy. But in this instance, we have kind of an amendment that goes in the opposite direction. I do believe, Senator, that districts that are not compliant, we need to review what is happening with this funding. So I think that's the intent, but I'm going to let the author
Thank
speak
you,
to this issue.
Thank you, Madam Chair and members. I concede this would appear to be a fairly extraordinary measure, extraordinary step to take. I understand that it's actually never been taken, but nevertheless, it's kind of the threshold test. How seriously are we going to take this policy, this proposed legislation? The simple fact is, if a school district says we're not going to do any of this, then what? The commissioner is tasked with some measure of responsibility to make sure that schools are taking the affirmative steps to keep students safe and supported when they go to school. And we leave so much of this bill to local authority and local control. But again, if a school decides they're absolutely going to completely and totally disregard this, no one has any sort of private right of action. No one has any ability to compel a school to take this step. It just, I don't think it would ever come to this, but at least it creates something behind the authority of the commissioner to make sure that these things actually do happen
Yeah.
across the state.
Thank you, Senator. Yeah, I do agree. I think that most of the, I think Senator Nelson and I talk a lot about the integration funding and came up with an amendment that we couldn't move forward, but, really in terms of what we need to do in order to really be clear, this funding is provided to accomplish specific things that are described in legislation. If they are not used for those purposes, then we need to give those resources to schools that are doing the work. So any other comments? Senator Nina.
Thank you, Madam Chair. I could almost accept that argument if this had funding. This does not have funding. This is an unfunded mandate. And, for example, you take a look at the language on page 14. Most of these are pretty straightforward. Are you hiring teachers that aren't licensed? That's easy to ascertain. Did you follow a rule? That's fairly easy to ascertain. Did you violate the Constitution? But the language we're adding is noncompliance with state laws regarding discrimination, and we've added, for example, gender identity. I'm not sure that's even a medical term. So what do we go to measure that? And then noncompliance with the prohibited conduct, and we've got some arguably somewhat vague language still left in this, and now it's completely up to the discretion of the commissioner not to consult with the attorneys. Did they dot their T and cross their I's? But just to determine, did you apply all of this well enough? And clearly, the bill needed more work. It came back here. I would argue it still needs some more work. Obviously, Senator Dibbles would disagree. I just find it concerning that we're not tying this authority with some sort of new funding. We're not saying, here's extra money to do these extra things, and if you don't do these extra things, we're going to keep the money. I could almost get that argument. But we're telling school districts, here's a whole new set of unfunded mandates, and there's some question about exactly how all of this applies. And if you don't apply it the right way per the commissioner's determination, they can withhold some or all of your money. And I just find that concerning.
Thank you, Senator Nino. Senator Nelson.
I'm just looking at that language, and it's always good to know what the different sections are. And I'm seeing on 14.27, it says funds can be held for or non-compliance with prohibited conduct under section 121A.031. What section is that?
That's this.
It's
The council can help us.
Can council tell us what that is? I'm not familiar with that statute.
Madam Chair, members, it's actually section 2 of the bill, so that's where the school student bullying policy is laid out.
Thank you.
Thank you, Senator. Any other questions, members? Senator Nino.
Madam Chair, I would like to roll call this vote.
Okay. A roll call has been called. Senators, I want to make sure, advice, and we're trying to, these issues are kind of finance related, so technically speaking, jurisdiction over finance is not within the authority of this committee, but we're going to take the amendment and we're going to, it's policy to change kind of the configuration of finance. It's kind of a stretch in there, but roll call has been called, and Brad will take roll.
Senator Torres Ray.
No.
Senator Dahl.
no.
Senator Nelson.
Yes.
Senator Carlson.
No.
Senator Chamberlain.
Yes.
Senator Clausen.
Yes.
Senator Franzen,
No.
Senator Johnson, Senator Kent,
No.
Senator Nino,
Yes.
Senator Peterson,
Yes.
Senator Rude,
Yes.
Senator Thompson,
Yes.
Senator Uyghur,
No.
Senator Wicklund.
No. No. There being 7 yes and 7 noes, the amendment is not adopted. Do we have another amendment? Senator Chamberlain.
This is just an oral amendment. Madam Chair, members, Senator Dibble. It has to do with data practices, and I think you did a little better with this. Page 4, 4.25, 4.26. And if we could, I would suggest tightening it up a bit. 4.25 starts with including immediately intervening to protect the target of the prohibited conduct. And then it says, at school administrators' discretion and consistent with state and federal data practices law. I would suggest striking after conduct on 4.25, striking at the school administrator's discretion, and then leaving, then it would read prohibited conduct and then consistent with state and federal data practices law. And I don't know if I got that completely right, but the goal is, if we're going to follow federal, if I recall correctly, our data practices law has some leeway for situations in which and where and when someone believes that if you notify a parent, there could be damage, or the child could be harmed. Well, if that is what the federal and state data practices law suggests, and correct me if I'm wrong, someone, but if that's what they suggest, then I don't know. The school administrator's discretion, I don't know why we would need that, because they already had to follow current law.
Senator, I think we're going to have to kind of have I want to have a clear understanding of the language
Sure.
you want to change. Could you repeat that so staff can take notes?
Sure.
Do we have, first of all, do we have a written amendment on that? We don't, okay.
Well, there might be an A40, I believe, but we could pull that out and take a look, but I think the A40 may have been tied to last night's, that
Okay, is
version.
A42? I think so. Okay, Senator, Council, Ms. Butler is approaching you to see if that the amendment that we have in writing actually reflects your
Right.
concern.
Yes, thank you.
It does?
Yes.
Okay. So we do have a written amendment to reflect Senator Chamberlain's.
So,
Let's make sure. Senator, do you have, the language is coming to you so that you can take a look at it?
Madam Chair, in the
Senator
meantime, if Senator Chamberlain could expand on exactly what this is accomplishing, what your intent is here.
Well, the intent is, and what we hope to get at is, my understanding on, we have a lot of attorneys here, but my understanding, I'm not as expert on our data privacy laws, but my understanding is that our data privacy laws, what they're trying to do here is protect the child. And you think that the child's parents, if notifying would do them harm, then you don't have to notify the child's parents. And I believe that's already consistent with state law. So if that is the case, and we have written in statute here, consistent with federal and state data practices law governing access to data, we would want, if that's the case, we follow law, I don't know why we would need the language at the school administrator's discretion. Does that make sense? if the law is already there and we had to follow it, and they already are, then I don't know what the intent of school administrator's discretion is. I would just want to make clear that the parents are always, always, always going to be considered to be contacted.
Madam-
Senator Dibble.
So I'll just mention or draw members' attention to the language at 4.28, where it says a presumption that a school district or school official will notify the parent of the reported targets or the parent of the actor. So we do create that presumption. But it was important to balance, I think, that phrase with the discretion. I mean, Senator Chamberlain is not incorrect, that current law does provide for the best interest of the child in those very rare instances where they might be exposed to even greater negative consequence. We'll get into some of those issues, but you know, this is just to provide clarity to the law. So in arguing in the other direction, the maintenance of this phrase does no harm, and keeping it in just provides some clarity to what we're trying to accomplish. I think certainly the folks who run the schools feel strongly about this, as is evidenced by the appearance of Mr. Aronson at the table.
Well, ultimately, you know, it has to be at somebody's discretion. Senator Peterson.
Thank you, Madam Chair. It seems to me that saying that something is at the school administrator's discretion and consistent with state and federal data practices law doesn't mean that just because you're doing something consistent with the data practices law that something else shouldn't necessarily be done. In this case, for example, if you had a very severe incident of whatever it was, the school administrator could decide to do something at their discretion. And consistent, we always have to be consistent with, I mean, almost saying consistent with state and federal law is, you don't have to even mention it in the statute. So leaving at the school administrator's discretion in there actually allows the person on site at the district to have more latitude about the instances in which they notify parents, that they don't have to just stick to the letter of the law. That's sort of what I'm getting out of it. And so the oral amendment may actually reduce the local school's ability to intervene potentially. I guess that's the way that I read it. I don't know what Senator other members think or Senator Dibble thinks about that. But.
Senator Dibble.
So, Madam Chair, we're trying to be responsive to this concern. And so we included the presumption of notice to parents. But it was important to maintain in the plain language of the bill that balance, that sometimes professionals have, frankly, a standard to which professional standards to which they need to adhere. They can't put kids in greater danger. But we just needed to, you know, to be responsive to the concern and the critique that was coming in. Frankly, I think it was inaccurate, but we put the language in the bill just to be clear. There would be presumption that parents would be notified, but wanted to kind of balance it off with you know, this discretionary aspect so that those who are responsible for implementing some of these provisions don't feel like the only operative language was the presumption language, that they're still able to exercise their professional judgment in the very uncommon instances where you might be exacerbating a situation, or at least give folks a little bit of time to address whatever might be going on, so that their services can be brought into the situation to resolve what might trigger that lack of notification to a parent
Senator
for
Dahl.
a period of time.
Thank you, Madam Chair. For what it's worth, I was reading it the way that Senator Peterson was reading. I think leaving it in there leaves more latitude for the district, and rather than being too prescriptive.
Madam,
Senator Chamberlain.
one final comment. You know, if we wanted to do this the right way, it's always, first and foremost, we want to make sure the parents are in the chain here in due process. And if we wanted to make this really clear, we would say, in accordance with Minnesota statute and federal statute, and just put it in there, and it would be clear. And they always have that discretion according to the statute. Statute says if a child would be put in greater danger, then we don't have to do X. That's in the statute. It's inherent in the statute. I think this adds confusion to it and somehow gives people the idea that, well, discretion here. So if we had a perfect world here, obviously, I would rewrite the whole thing and just put the statute number in there that they have to refer to. And I don't know the top of my head, then we wouldn't need that. There's always a presumption. And I must say, Madam Chair and Senator Dahl, if you're talking about latitude to the school districts, this doesn't give you latitude. This 15, 20-page bill doesn't give you latitude to the school districts. In fact, it doesn't give latitude to the parents. And that's my concern here. This does not give much latitude to the parents. I want to make sure the parents are in this chain, and if the school officials follow the law, they know that they don't have to notify the parents if they believe that'll put the child in danger. So I think some places latitude is good, some places it's not. In this case, I think we need to be very clear that the teachers, the educators, the school, must do whatever they can to notify those parents in the event that something happens. So I think language change would help make it clear. That's just my humble opinion. Thank you. That's my final comment.
Thank you, Senator. So I think we're ready to vote. Any other questions? So on
Madam Chair, let's roll call this. What the heck?
Okay. Thank you. Try to do these fast.
First one of the year.
I have a lot of time, so. Okay, on the A42 amendment, a roll call has been called, and staff will proceed to call members.
Senator Torres Ray.
No.
Senator Dahl.
No.
Senator Nelson.
No.
Senator Carlson.
No.
Senator Chamberlain.
Yes.
Senator Clausen.
No.
Senator Franzen.
No.
Senator Johnson.
No.
Senator Kent.
No.
Senator Nenow.
Yes.
Senator Peterson.
No.
Senator Rude.
Yes.
Senator Thompson.
Yes.
Senator Uyghur.
No.
Senator Wicklund.
No.
We have 11 noes and 4 yes. The amendment is not adopted. Members, do you have any other amendments?
Madam Chair?
Senator Nelson.
I have a small oral amendment, and that would be on line 2.18. As the bill read that was introduced this morning, it read school benefits, comma, services, comma, or privileges, and in the definition of bullying. But my understanding is in one of the oral amendments to the amendment that we adopted, the word and was changed to or. And we need to change it back to the word and. And I just wanted to clarify that. So we need to go back to the original language. When we were defining bullying, one of the concerns with this bill is that the definition of bullying was so broad that our school districts would not be able to adequately implement the policy. And so going back to tightening up that definition of bullying, as you originally intended, Senator Dibble, where 2.18 ended in the word and, rather than the word or. So my oral amendment is to replace the word or with the word and on line 2.18.
So,
Thank you, Senator.
Madam Chair, this is a slightly confused discussion. The issue is, maybe council can help us. We're not trying to so narrow the definition of bullying so as to make to make it such that all these elements have to be present, therefore nothing would ever be bullying. So that's why the or. That being said,
We do want the and.
we did have some conversation after committee. It is true that the imbalance of power element and the repeated, the repetition element and aspect both do need to be present for us to be able to say, this is not harassment, this has risen to the level of bullying, and it needs to effectuate it needs to be recognized as such and dealt with as such. But when you have the or, when you have the and there, then perhaps very few things then could be considered bullying, because then you're saying that items that interfere with both an individual's ability to access, have fair access to their educational opportunities, as well as the entire school would need to be present. And we didn't want both of those elements to have to be present. An individual is having a problem and the whole school at the same time is having a problem, then what would be bullying? Almost nothing, or very few instances would be considered bullying. So we were trying to reconcile that issue, hit on a problem. We want the operative and, so that both the pattern piece, so that both 1 and 2 are present in all instances. We were actually going to try to fix that on our way out of here. We can fix it right now here. Maybe Mr. Aronson can help us. He's a great technician on these elements.
Thank you, Senator. I know that it's one word, but I know that significant work has gone into this, because it does have some significance. So thank you for bringing that to our attention. Mr. Aronson, could you please identify yourself for the record and
Madam
proceed
Chair and members,
with your...
I'm Roger Aronson. I represent the elementary and secondary principal associations. I know that Senator Nelson is well-intended with her amendment. I don't think you'd want to adopt it. And the reason I'd say that is, we actually looked at that this morning when this was crafted, and if you adopted that as the rule, the standard would be so high that almost nothing would ever be bullying. And we did talk to, because you'd need 1, 2, 3, and 4. I mean, you'd have to have the bad conduct. It would have to be a pattern. You'd have to have material and substantial interference with the child, and you'd have to have disruption of the school. I mean, those incidents are far above what we're typically trying to get to with this process in terms of bullying. A lot of it is much lower than that. It may just be intimidating behavior that has an effect on a child that is has a pattern and the imbalance of power. So that's a much lower deal. So that's why you wouldn't want to do the amendment. But we did visit with Senator Clausen in the interim here a bit this morning and this afternoon, and with Senator Dibble as well, that we do want to link 1 and 2. 1 and 2 should be linked. The imbalance of power and the pattern, if you do the traditional Oveus definition of bullying, and if you look at the Anoka definition and you look at the Rosemont, Egan, Apple Valley definitions that we've been working with those folks, those two are linked. We think that that works, and number 3, that could be an alternative. 1 and 2 linked, 3 an alternative. One incident may be so large that if it materially and substantially interferes with the student, it may not be a pattern, but then that would rise to the level of something that would be bullying as far as we're concerned. We did mention 4 has been hanging around for a while, but we're not really sure what 4 does in terms of disrupting the, quote, work or discipline of the school. I think it was well-intended, but I don't think it adds anything to the standard. So Senator Nelson's along the right path of working on this in terms of having those as individual elements. 1, 2, 3, and 4. We do think 1 and 2 should be linked, and 3 should be separate.
Madam Chair?
Thank you. Senator Nelson.
Yes, with that discussion then, which also gets to the point that point 4 on line 2.19 is rather vague. We're not exactly sure what it adds to the bill. So I'll amend my oral amendment in addition to deleting and on 2.18 and inserting or. We'll just delete line 2.19. So we still have that tight definition that those who implement this policy are looking for, but we do not have the fuzzy requirement that Mr. Arneson mentioned on line 2.19.
Any comments, members? Is it clear to you what the amendment does?
Madam Chair?
Senator Clausen?
Yes, thank you. We have had discussions on this. I think we recognize that we do need to make some changes. I feel in this kind of being stressed into doing this. I'd really like to spend a little bit more time reviewing it and on the next stop, in the next committee, make sure we correct this area.
Senator Clausen,
So I'm speaking against the
I am very
amendment.
sorry, but you have had ample opportunity. You can bring this next year. It has to come back to policy. You can take it outside. We have 16 more that we have an hour to go. But we need to make a decision tonight. So it's up to the members. I understand that, Senator Clausen. I know you've worked incredibly hard. I cannot thank you enough for all of the conversations you've had, but there are nuances to this policy that are gonna come back time and time again, and that's okay. That's what this process is for. Senator Nino.
I just, in the context of the good senator's comments, where is this bill going to be headed, assuming it moves out of here tonight?
Senator Nino, this is headed to Finance. It is clear to me that the Chair of Finance does not want to deal with policy because clearly he will not have the input from committee members like you. I don't know who's in Finance, but I don't think there is. Senator Uyghur is the only one in Finance, of course. So it's very complicated.
Madam Chair.
We're not going to deal with policy and finance. Senator Dibble.
So if I understand,
Senator
I was
Nelson's.
thinking about a couple different
Yeah,
things here,
yeah.
so I just want to repeat Senator Nelson's motion. It would be to place the word "and" at the end of line 2.14.
2.18?
On 4.
And then
Well,
delete.
Well, I'm sorry, if we're deleting 2.19, we wouldn't need an "and" there. Are you deleting 2.19?
Yes, deleting light, Madam Chair? Madam Chair?
Yes, Senator Nelson.
Yes, deleting line 2.19. And the first part of the oral amendment was striking the word "or" at the end of 2.18 and putting in the word, inserting the word "and" in its place.
Yeah, but Madam Chair, there's nothing
Senator
to
Dibble.
bridge. That "and" would be unnecessary if 2.19 were to go. But
Oh, yes.
here's what I'll suggest,
Yes.
is we put an
Yes.
"and" after
Senator.
2.14. We put an "or" at the end of 2.15. And then I think we're good to go, and I appreciate Senator Clausen's effort to have more conversation after this point, but I actually think what happened was we had this a large part of this conversation that got a little bit lost in the flurry of emails from Pina Colada land.
Senator Dibble, could you repeat then what the language that is suggested to address this issue? Let's Senator Dibble
All right,
address this, and then
I
I'll
would
get back to you,
suggest
Senator Peterson.
respectfully that we place an "and" at the end of line 2.14, and we place an "or" at the end of 2.15. What that does is it links imbalance of power, repeated conduct, but delinks to some degree the substantial and material interference with a student's educational opportunities. And then, of course, it eliminates the school-wide effects of a bullying incident, because that's already dealt with in existing law and existing precedent.
So, Madam Chair?
Senator Nelson.
I think there's been enough discussion around this that it's probably about as clear as mud to all concerned. I think it's an important policy decision. Let me just go on the record stating that I think it's absolutely essential that conduct is repeated, not just one of the incidents that would be, not a one-time incident would necessarily be defined as bullying. But with that, Madam Chair, I believe that I'm going to withdraw my amendment. But just register, there's obviously some work left to do on this bill. And so with that, I'll withdraw the amendment and hope that before it hits its next stop, it can be further refined.
Thank you, Senator. Senator Peterson, did you have a question? Would you like to move?
In light of the withdrawal, no, Madam Chair.
Thank you. Any other amendments, members?
Madam Chair.
Senator Franzen?
Thank you. I think I was tracking with Senator Dibble, and I would move that change if he still thinks it's appropriate to add the language on line 2.14, add the and, so it's linking 1 and 2. So to Senator Nelson's comment, you would need both 1 and 2 to be present, and then you would add or at the end of 2.15, and that would solve our issues.
And eliminate 2.19.
So eliminating.
Senator Franzen, would you like to think about this for a little bit, and then you bring it back to us, because we have several, so just think about it, and then you bring your oral amendment in a minute. We'll come back to this. So let's,
Okay.
if you can talk to staff and just make sure you, or if you're ready, you can read it back again.
I thought I was ready. I was just
Okay,
trying to.
if you're ready, go ahead.
Yeah.
Sorry.
Yep.
Okay,
Just
go ahead and read it again.
So I'll read verbatim, starting in line point 214, in prohibited conduct and the target of the behavior, and line 2.15, the conduct is repeated or forms a pattern, or in line point 216, materially and substantially interferes with a student's educational opportunities, and so forth. And I believe Senator Dibble also wants to delete the last or in 2.18 and strike 2.19.
Yes.
Senator Dibble,
Yes, that is correct.
you agree with that amendment? Members, do you have any questions? Senator Peterson?
Thank you, Madam Chair. So I will say what I was going to say before. I actually think that what we've just done there is actually dramatically expand what could be defined as bullying. If you look at the first clause would be, obviously actual or perceived imbalance of power, and the conduct is repeated, or would signify that clause 2 is not necessary and that clause 3 could replace clause 2. That would dramatically expand the definition and would mean that the conduct would not need to be repeated or form a pattern in order to be defined as bullying. I think this is a dramatic expansion of the definition of bullying, and I don't see how it could be read any other way, quite frankly. And I'd like to get Scott Kroonquist and Roger Arnson to weigh in on that. But if you're putting an or after clause 2, you would signify that clause 2 isn't a mandatory clause in the event that clause 3 is present. And if that's the case, it actually, like I said, it essentially means that clause 3 is the only thing that matters, and clause 3 could happen in one instance. I think we ought not make this sort of decision on the fly, members, and it seems like there's been a lot of confusion over the last 30 minutes, and I would strongly urge the committee not to make this change.
Madam Chair?
Madam Chair.
Yeah, I would agree. Everybody knows this. We have a better alternative bill, but, as much as I disagree with the or, Senator Nelson's original amendment, let's not do anything that's going to make it, in my opinion, worse. I'm willing to let Senator Dibble have that before we, as Senator Peterson has alluded to, start changing conjunctions and commas and changing the whole meaning of this bill. Well, not the whole meaning of the bill, but expanding this definition. I suggest, as much as this pains me, not to tinker with this anymore.
Any other comments, members? Senator Franzen?
Madam Chair, I'm just confused. We're in the policy committee to make the changes that we need to make to this bill, and we're all here trying to work on them, and then there's no engagement to do so. So I understand what Senator Dibble's trying to do. I understand what it means, and we did have a brief conversation here that if one incident could be material and substantial, that could rise to the level of bullying. That's how I read this. And yes, I'm an attorney, and this is how I interpret it. So if it's different, love to hear from counsel, whether on the testifying table or from our Senate counsel. But a single incident could be material enough and substantial enough to rise to the level. That's how I read the bill.
Madam Chair and Senator Franson, I hate to interrupt here,
Senator
but
Chamberlain.
but goodness, that's what attorneys do all the time, right? You find a comma or a conjunction out there in the courtroom and say, "Yep," it flips it. You take a law of large numbers. If you take 1,000 people, they're going to come up half and half on this. There's no way to say that your definition there in that situation is definitive, and therein lies one of the biggest problems with this bill. And you and all of us have just exhibited it by the very conversation of or and, or deleting line 19. This is going to be a nightmare. Whether you put or, whether we use your definition or we leave it the same, it's going to be a problem. So do as you wish, but you have demonstrated the utter problem, the sheer problem with this bill. So good luck.
Madam Chair.
Senator, before I get your comment, I want to make absolutely sure that this is clear to the audience. The language as is being changed. People are proposing to change. One change causes a problem, so it's being trying to clarify in this direction. And the language, the people who are going to implement this language said the language is fine. Okay, so amendments that are coming in both directions, Senator Chamberlain, are confusing what is already being done. So we're trying to accommodate your request to come back to clarify the language. We're giving you time to do what you say needs to be done to clarify the language. So this is the result of that. So I want to make sure that it is clear to the audience that this language has been vetted for months, and it's fine. But we're trying to change it now, and this is the process. This is our democratic process. So I hope people in the audience understand. So Senator Chamberlain, I just, with all due respect, it is this process we're trying to kind of confuse the language. Senator Peterson.
Thank you, Madam Chair, and I'll reserve my comments just to this amendment and this issue here, and I'll have comments on the broader bill later. And I am here to do the work, and this is the real work of sort of figuring this stuff out. And I think we had a suggestion from Mr. Kroonquist and some of the staff. I do not think, however, that Senator Franson's stated intention of having one incident is actually the intent of Senator Dibble or Roger Aronson or AMSD. Correct me if I'm wrong, but I think what we could do is eliminate on 2.15, we could strike 2, move that line up to 2.14 after a comma on behavior so that those two things are clearly codependent. And then we could place an or after that so that 3 would then obviously become clause 2, and clause 2 could be preceded by an or with the first 2 clauses mended into one clause. I'd like to know what Senator Dibble thinks about that.
Senator Dibble.
So Madam Chair, that would have the effect, Senator Peterson is correct, of establishing that a pattern of bullying would need to be present in all instances. It could not be one occasion event. That is true. I guess that's a policy decision that this committee would have to make. That is very common in a lot of the accepted definitions of bullying, as the literature. I mean, I have it here if you want to see it. Some organizations disagree, and they feel strongly that the one incident could very well be construed to be bullying. With that, I will say that we do have, we took, for example, harassing out of the statute. So we have narrowed the definition, by the way. Haven't expanded anything. We've narrowed the definition quite a bit, through this process. We've done some other things that narrow the definition. So that would be the effect of doing that, if the committee believes that's the right thing to do. And there is some wisdom. I know Senator Clausen feels strongly, and that's kind of how the Apple Valley policy works and the Anoka policy works, that as advised by the Department of Justice. You know, I philosophically disagree, but the administrators think that the pattern element should be present. More than one incident to rise to the level of what we would refer to as bullying.
Senator Dibble, I'm sorry to interrupt you, but before we go there, which is a new thing, I have to follow procedure here. So Senator Franzen had a motion proposal before the committee, and we need to get back to that, resolve that, and then we can entertain Senator Peterson's follow-up motion.
Madam
And-
Chair, in light of Senator Dibble's comments right now, it sounds like he's taking a different approach, so I would withdraw my motion.
Thank you, Senator Franzen. Senator Peterson.
I'd offer the amendment that I previously stated, which would be to strike 2 on 2.15. Actually, you would strike line 2.15. You would add the conduct is repeated or forms a pattern after behavior on line 2.14. And then the word or after that. Strike 3 and then change that below clause 3 to clause 2 on 2.16. And then I think that gets us to where we want to be. And then strike line 219 altogether, and the and or whatever it is at this point.
Madam Chair, I support the amendment.
And finally,
So-
Madam Chair, you
Senator Uyghur.
delete the semicolon and add a period.
So that was kind of part of what Mr. Arneson wanted to kind of get to the consolidation of the first two, correct?
Yes, Madam Chair. And Madam Chair, I might add, I think Senator Franzen was absolutely right when she said some conduct individually may rise to such a high level that that would be bullying as well, and that would be maintained in the amendment as currently.
Okay, members, I want to make sure that we have Senator Dahl.
Madam Chair, just to be clear, is Senator Dibble then supporting Peterson's oral amendment? Thank you.
Madam Chair, yes.
Senator Dibble.
Yes, I am.
Okay.
If we could have staff read that back for us, that'd be great.
Okay, Ms. Butler.
Madam Chair, members, on line 2.14, after behavior, insert and the conduct is repeated or forms a pattern. On line 2.15, you delete line 2.15. And I'm sorry, and I forgot actually at the end of that. Let me go back. Sorry. 2.14, after behavior, insert and the conduct is repeated or forms a pattern. After the semicolon, insert an or. Then line 2.15, you delete that line. Then 2.16, you delete 3 and insert 2. On 2.18, you delete the semicolon as well as or, and then delete and insert a period, and then delete 2.19.
That sounds right.
Senator Dibble.
Madam Chair,
That's correct.
That's correct.
Senator Clausen.
Yes, thank you, Madam Chair. After we get through this, I've got some amendments that I'm going to add that have been taken from the Anoka Hennepin County District and the Apple Valley Rosemont District. The Justice Department has looked at the Anoka definition. I think one of the things that we're missing and why I was advocating for a little bit more time was we're missing some descriptions of the kinds of behavior to look for. We really haven't identified that. We talked about there's a imbalance of power. We talked about that it forms a pattern, but like what are we really looking for? So I'm going to add some amendments that talks about physical or psychological harm, reasonable fear of harm, willful negative behavior towards a victim. I'm going to give some examples, so I will be offering another amendment that tries to get to more specific definition. And again, these have been vetted out by the Department of Justice and are currently in 2 of the largest school districts in the state.
Senator Clausen, question. I thought that 224, all of that language is language that you worked on and suggested that be incorporated into. Is that language, is that the language that you are amending?
I think, yes, we can move some of this up above and perhaps remove some of it from below. Not to complicate things.
Madam Chair,
Senator Johnson.
will that be a written amendment?
I don't have it in writing, no.
Could it
Currently.
be made into a written amendment if we, I think that is what is difficult for people when you start changing small words and following what's going on as people are trying to listen and keep track. But, so if there's any way to get it into a written form, that would be good, I believe. I would hope you'd ask for that.
Senator Clausen, if you wish to entertain, the committee to entertain an amendment, we have a few amendments, we have some time. You're welcome to do that, but that action needs to be taken in this committee. This is the policy committee, and we need to take it here. So to tell the public and to tell the author and to tell the members that you're going to have time to take action on this bill now is really incorrect, is inappropriate. I cannot give you that opportunity because I'm not going to have a hearing on this bill anymore. This is it. The bill has to move. So if you could work on that language to incorporate that now. If not, we'll have to work with the school districts and with members in the future to bring that back to your attention. But at this point, we have to take care of the amendments that are in front of us. Any
Madam Chair,
other
I think
amendments?
There's a motion on the floor right, to be considered right now.
That's correct. Thank you, Senator. Please, let's get back to this. I think you already read the language. Members, do you have any question on Senator Peterson's motion? And I will appreciate, members, if you stay on those motions, because I do appreciate that you want to have input in this process, and I appreciate that you're trying to make this bill better. I really, really appreciate that. But just stay with the motion so I don't get distracted. On that motion, all of those in favor signify by saying aye.
Aye.
Aye. Those opposed say no. The motion is adopted. So any other amendments? Senator Nino.
Thank you, Madam Chair. I'm not sure if I need to move to amend this or not, but the language on, starting at 3.12, but particularly on 3.13, the placement of to the extent practicable, and now he's left the table. I thought Mr. Aronson had pointed to this at one point and said that this made things easier for them. And my inference was that his interpretation was that the shall adopt, implement, and on a cycle consistent, et cetera, was the language that this phrase, to the extent practicable, was modifying. But when I read it, to me, it's ambiguous. I don't know if that is modifying the previous language or both sets, the first part and second part of that sentence. And I wanted to maybe ask counsel, if the intent was to the extent practicable, have districts and schools consult with students, parents, and community organizations, or if the intent was, to the extent practicable, adopt, implement, and et cetera, or if that's supposed to apply to both, my guess is it's supposed to apply to the second half. And if that's the case, would that be better placed somewhere after the shall adopt?
Madam Chair,
Thank you. Senator Dibble.
I can answer the question. To the extent practicable applies to the consultation with students, parents, and community organizations that was responsive to a concern that was raised by one of the organizations, that somehow we were mandating that school boards, school districts bring in external organizations for the purpose of developing and adopting the policies. So we just tried to make clear that, you know, there should be, you know, community engagement. It's not a mandate. It's a good idea. And so if it's practical, sure. If it's not, don't. And then the second part was modified so that the policies need not be reviewed on an annual basis, but just kind of on a normal cycle that districts have established for that kind of thing. Districts review their policies on some sort of a cycle that they've determined for themselves. And these policies once in a while should be dusted off, take a look, still good to go, need some revision, and then and on they go.
You know,
So-
Senator Dibble, that and Senator Nino, I'm going to do a research project on how many times, to the extent practicable, is actually repeated in policy in education. It's unbelievable. In part, I understand why, you know, it's very difficult when you say, you know, provide input from parents or get feedback from the community, involve students. So what does that mean? You know, does it mean every student, every parent, every community member? So that language is actually quite popular in our statutes in education, just to give kind of, you know, the administrators and teachers kind of that latitude of, you know, you have to make it practicable. It has to stop somewhere. Senator Nino.
Madam Chair, I'm not going to try and rewrite your sentence, but I think the way it's structured, it's ambiguous. You could easily read this, that districts and schools in consultation with students, parents, and community organizations, to the extent practicable, shall adopt, implement, and on a cycle consistent, et cetera, et cetera, et cetera. I guess that's just food for thought, Senator Dibble, if you want to be clear with your language or leave that the way it is.
Thank you, Senator. I think that that's a good point. I think the placement of it may be something, but again, we're not going to, hopefully this is clear enough. Senator Nino.
Thank you, Madam Chair. And on the same page, in a slightly different vein, but it was another comment made by Mr. Aronson about, and I think this is the language he was referring to, not having to do as much reporting on remedial responses. And if I heard correctly, and maybe I misheard, but if I heard correctly, when I read this language, I don't see where there's any kind of reduction, because districts and schools, well, it reads in the negative. Districts and schools need not report the use of remedial responses when their use is unrelated to any particular incident. Turn that around and reading it in the positive, districts and schools must report when it's related to any particular incident. Well, there would not be a remedial response unless there was an incident.
Senator, I have to apologize. We found the non-practicable in 313, but I think you're working out of the 831. We need to, no? I cannot find it.
I'm sorry, it's right above that, literally
Okay,
right above that,
okay.
3.10.
We're just trying to find it.
310 and 311, I'm sorry.
Okay, thank you. Sorry for the interruption. I just wanted to find it.
Madam Chair,
Senator Dibble.
we can delete that sentence.
I don't, Madam Chair, I don't necessarily have a problem with the sentence, other than I don't think it affects any reduction in reporting.
Right. Senator
Chair.
Dibble, do you wish to delete it? I don't, you know, we don't need to act on it. Let's don't act as if this is the final day. We can come back, as I don't know how many times I have to say this, but Senator Dibble, what is your pleasure? You're the author of this bill.
Well, Madam Chair, I would disagree with Senator Nino's point. There's no reporting required. So that's clear. There is. I'd like to
senator
see
does
where it's
not have
required.
an amendment.
This sentence would be inoperative because it's a carryover from when there was some reporting required, you know, to the commissioner, to the agency. So, you know, we can leave it, we can keep it, doesn't matter, it has no effect.
I think Senator Nino,
Madam Chair,
I don't know if you have it.
if it's irrelevant or redundant language, I guess I just move to strike it out of there. It's the unsession, we don't need to add more.
Thank you, Senator, for adding to that, to that word. Senator Dibble.
If this bill becomes an official unsession bill, then I'm in favor of this amendment.
You can add that
All right.
point to the
I
governor.
support the amendment.
Do you support the amendment?
Yes.
Thank you. So Senator Nino moves to remove from 310 on districts and schools need not report to use all the way to conduct. All of those in favor signify by saying aye.
Aye.
Those opposed say no. The amendment is adopted. Any other amendments?
Madam Chair.
Senator Nelson.
Oh, thank you, Madam Chair. Well, it's pretty obvious after this afternoon and this evening's hearing that we all realize that bullying is a serious problem. We know that it has complex causes. We also know that there are definite and very painful consequences for the victims of this behavior. We heard that in some of our testimony today. Certainly, I've visited with students from my school districts about that. And I believe that we must strengthen those protections for our children. However, it's very important that we build those protections in a manner that is actually doable, something that can be done. And so it's very important that we assist our schools to continue to be a part of that solution. And so what's so important is the remedies that we prescribe here must be doable. They must be something implementable that our school districts can implement to get to the result that we all want, which is to deter bullying and prohibit bullying and train students how to be bystander interventionists in bullying and our staff. So that is incredibly important. And what I think we've seen this afternoon and particularly this evening is there's still a lot of questions about the amendment that we received this afternoon, and also that it really hasn't been tried in some places, this particular definition. And so with that, Madam Chair, I offer the A38 amendment. It is 3 pages. It is a delete all amendment. And I will tell you that this amendment is based off of the North Dakota anti-bullying model, which has been rated by the federal government antibullying.gov as A++. It is also, interestingly enough, I found that our Attorney General also recommended that it be a model policy for Minnesota. And so we're not entering that uncharted territory. This is an anti-bullying policy that has been adopted, it's been implemented, and it's been rated. And so I offer this policy, and also let me add the current policy that Senator Dibble has before us. None of the school districts in my district have supported that policy. They're concerned about its implementation and about its price tag. And is it doable? So with that, I would move the A38 amendment for discussion.
Thank you, Senator Nelson. Members, do you have the A38 amendment? I know you need a couple of minutes at least to read it, please, I'm going to just give you a couple of minutes to read this and make sure you have an understanding of what's being proposed.
Madam Chair, while we're doing
Senator
that.
Chamberlain.
Thank you, Madam Chair, members. I'd just like to, emphasize what Senator Nelson said. This has been tried. It's in effect now. It's been supported by the AG. It's got a good rating. And this protects all kids. There's nothing in here that doesn't say all, right? All kids, no matter who you are, what you do, where you come from, all kids. This is understandable. This is doable. We know it's doable because it's been done in North Dakota for several years. And I'm sure, I hope and pray somebody would take it, but I'm sure that's not going to be the case tonight. But you look at this, it's simple, it's direct, it's to the point, and it protects all kids. And I would encourage people to look at this, read it, and I would just say this, final comments, and then I think I won't talk at all the rest of the time here, Madam Chair. is that with Senate House File 826, we want to protect kids. I was bullied just like anybody else. I was in that position, and I want to protect kids too. So I understand what it's about. I understand what kids go through when that happens. So, but with 826, I've talked to people who have supported the bill. I said, have you read it? Nope. Have you read the alternative? Nope. Have you been to the schools and talked to teachers? Nope. Because anti-bullying is something everybody supports. They just understand that. We do. But they didn't take the time to read 826. Folks, you don't know what you're asking for here. 826, you do not know what the ultimate consequences are going to be with this. We just spent 20 minutes talking about or and. You don't know what you're going to get with this. And I think you're not going to like it in the end. But I would urge you to have an open mind, look at 2411. It's more than 37 words, but it's gotten the job done in North Dakota. Thank you.
Thank you, Senator. Senator Nelson, I have a question about
Yes, Madam Chair.
211, about notification to law enforcement. I don't know if under current policy we actually have a requirement for notification of law enforcement personnel for an investigation. Could you tell me a little bit more? You know, when I read this, it was just kind of it raised some concerns to me about, you know, what the notification implies here.
Yes, Madam Chair. My understanding that if there is a reasonable suspicion of a crime, that law enforcement would be notified. It's just further clarifying that at any time when there would be a suspicion of a crime, if the bullying were to the level of a crime, that certainly law enforcement would be notified. So is that the current practice, and is that current law? I think that's current practice. I can't, and it certainly very well may be a current law as well.
I was just kind of, it will require further review on my part, but
Yes.
thank you. I just wanted to. Members, do you have any questions on the A38 amendment?
Madam Chair.
Thank you.
Might I just add, thank you so much, Madam Chair. And so, you know, school teachers are mandatory reporters, so I don't think that that's anything unusual. It's just spelling that out. But members, I've offered this in the spirit of a bill that can be implemented that is not does not have detractors, that people who are charged with making sure our schools are a safe place of learning can actually do this. I will add one other thing that might not be the purview of this committee, but I know everyone at this table and everyone in the Senate is concerned about that, and that is making sure that we close the achievement gap. We have the worst achievement gap in the nation. And the fiscal note on Senate File 826 was $20 million per year. I also received documentation thinking that maybe that was an underestimate. I'm not sure if that's correct or not. But with take maybe an average teacher salary, you know, that's 400 teachers that would not be in our classrooms because of funding that would be used for the climate center and whatever else the fiscal analysts looked at in implementation of this bill. And, you know, if we're going to close this achievement gap, we need to start really focusing on early literacy, making sure kids enter kindergarten ready to learn, make sure they're reading at the end of third grade. I know we share those desires, and we always have limited funds. And so I think that's something we need to consider. And I know Senator Uyghur, you'll definitely be considering that
Thank you,
in
Senator.
your committee.
I'm aware of the many amendments we have, and we're going to cut in 25 minutes. So let's take a vote on this amendment. All of
Madam
those
Chair?
in favor?
Oh.
Senator Nelson.
We'll have a roll call on this amendment.
Okay. Please
Madam-
be ready for a roll call.
Madam Chair,
Okay.
and I would request under Senate Rule 1210 that it be recorded in the journal.
Okay, it will be recorded in the journal. Okay, please call the names. Brett?
Senator Torres-Ray.
No.
Senator Dahl.
No.
Senator Nelson.
Yes.
Senator Carlson.
No.
Senator Chamberlain,
Yes.
Senator Clausen,
No.
Senator Franzen,
No.
Senator Johnson,
No.
Senator Kent,
No.
Senator Nino,
Yes.
Senator Peterson,
Yes.
Senator Rude,
Yes.
Senator Thompson,
Yes.
Senator Uyghur,
No.
Senator Wickland.
No.
We have 9 noes and 6 yes. The amendment is not adopted. We have any other amendments, members? Senator Nino and then Senator Chamberlain.
Well, if Senator Chamberlain's going to talk, let him go.
Senator Chamberlain.
Madam Chair, members, 844 amendment. Just briefly, while that's being passed out, I know in the current bill, there is a brief mention, I forget what section, about protecting First Amendment rights. This goes a little bit broader, make sure we go a little bit further and catch everybody in that area. Thank you.
Thank you.
Where am I in here?
So to clarify, members, we are on page 7.
Yep.
It's because this amendment was previous language.
Right.
Sorry.
On page 5. Page 5, right.
Sorry. Page 5 is fine. Sorry about that. I guess I'm more confused. Sorry. Staff is just clarifying that this provision is included in number 7. Ms. Butler, could you clarify that? Sorry about that. Misunderstood.
Madam Chair, members, I was trying to point out to Madam Chair that on page 7, lines 11 and 12, talk about the section regarding the policy is, does not, at 11, interfere with a person's rights of religious expression and free speech and expression under the First Amendment of the United States Constitution.
So Senator Chamberlain, I think this language is, already incorporated into the policy that is being proposed.
Yeah, this is more specific.
Yeah,
You see, Senator
Madam-
Chamberlain,
Madam-
somebody was advocating for.
Madam Chair, what we're talking about here is policy. What we want to do is get this into policy. On page 7, we're talking about, it's a statement in the bill. So when a school writes a policy, it must not infringe upon a student's First Amendment rights. So we want to put it in policy, not just stated in the bill. So that would be why, exactly where you want to put it. This was written off the prior amendment from the 6th, so we did the best we could, but that's the intent. The intent is get it in the school policy. When the school puts together their policy and submits it, it's got to include this in it.
Senator, I think this has the same effect, but Senator Dibble, what's your opinion?
Right, Madam Chair, I would tend to agree with you. I think, when it says the section does not interfere with a person's rights of religious expression and free speech and expression on the First Amendment of the United States Constitution, section in question, section 2, which is kind of the whole section that deals with both the formation of the implementing policies and their their implementation. I think that language is pretty clear. That's what Section 2 does. It's subdivision 7 of Section.
As applied to this policy. Members, do you have any questions on this issue? Okay, so we're going to vote on the A44 amendment.
Just one last point, and I'll be quiet, is that, I thought I promised not to talk, but one last point is that, again, you know, everything else is listed out in policy, all the details we want in policy, but that is why we want this there. Other details were important enough to put in policy for school and the state model policy. That's why I think it's important enough to put this in. So that's my final word on this. If everything else has to be in policy because we believe it's important enough, I believe this is as well. Thank you.
Madam
Thank
Chair.
you, Senator.
I mean,
Senator Dibble, briefly.
I'll leave it for the committee to decide. I have no strenuous objection. I think that the matter is dealt with in the language of the bill. But, you know, committee members can decide for themselves if this is important to make sure that the language of policies that school districts adopt have a statement like this in them.
I'd like to request a roll call, Madam Chair.
Thank you, Senator Peterson. If the staff could prepare
Madam
to
Chair.
call. Yes, Senator Clausen?
Just a comment. I think this holds it really to a higher standard because it talks about materially disrupting the learning environment. It may not do that, but it may fall under one of those definitions that we just worked through of infringing upon an individual's right. And so I would encourage people to vote no on this.
Thank you, Senator. Could you call?
Madam Chair.
Senator Uyghur.
I agree with Senator Clausen. Was wondering if Senator Chamberlain would be open to putting a period after viewpoint at 1.5 and deleting the remaining. Then it's a clear expression of First Amendment.
Madam Chair, while they're talking about that, I would say that policy does sometime, is a little different sometimes than our constitutional rights. As I teach the Constitution, and they don't need a warrant to search your locker. You know, the school can say no vulgar language at the school assembly. I'm a very strong believer in the Constitution and the Bill of Rights, but I know there's plenty of policies where you're sometimes a student, because of the learning environment and the safety, the policies don't always, I mean, sometimes those rights are different for when you enter the school building. So be careful with that. I think, as Senator Dibble said, I think that the language that's in there refers to the policy earlier, and I just worry about getting too specific, because we have lots of school policies where the students' rights are not the same as an adult's out on the public streets.
Madam Chair, one last comment. Thank you, Madam Chair. To Senator Uyghur's point, I was reminded this is Supreme Court language regarding the issue, and to put we would not want to put a period after viewpoint, because if someone comes in the classroom, as I was reminded, wearing a swastika on their T-shirt, that can be disruptive. So to the extent the student's expression does not materially disrupt the learning environment, that is why that part is there. So yes, there are a lot of times when the students don't have the same rights in the school, I suppose, but this is a big bill. It's a big bill, and what it's essentially doing and what is talking about speech and association and what your beliefs are and how you express them, and just trying to get that in there. But with that, I'll be quiet.
Thank you,
Madam
Senator.
Chair,
On
I
the
just
A4
briefly respond that
Senator
there's
Uyghur.
other examples where the speech may be bullying, where it may not be disruptive to the classroom through other examples. And Senator Clausen cited that. And for the reason that Senator Dibble mentioned that this is already covered, I would oppose the amendment.
Thank you. On the A44 amendment, a roll has been requested, and staff will call the roll.
Senator Torres-Ray.
No.
Senator Dahl.
No.
Senator Nelson.
Yes.
Senator Carlson.
No.
Senator Chamberlain,
Yes.
Senator Clausen,
No.
Senator Franzen,
No.
Senator Johnson,
No.
Senator Kent,
No.
Senator Nino,
Yes.
Senator Peterson,
Yes.
Senator Rude,
Yes.
Senator Thompson,
Yes.
Senator Uyghur,
No.
Senator Wickland.
No.
There being 9 noes and 6 yes, the amendment is not adopted. Any other amendments, members? Senator Nino,
I only have one more, Madam Chair.
thank you. We appreciate that.
836.
836 amendment. Senator Nino.
Thank you, Madam Chair. This amendment eliminates the anonymous reporting and would guarantee, if it was adopted, would guarantee what we consider, for the lawyers in the room, a basic right to face your accuser and to make a defense for yourself. The bill already prohibits any kind of retaliation, so that's covered. Students cannot engage in any kind of retaliatory behavior. That is defined, one of the definitions included in prohibited behavior. This just sets up basic equity for someone who's been, in those circumstances particularly, where someone who's been unjustly accused, to give them the opportunity to face their accuser and say, here's why you're wrong.
Senator, thank you. I pause for a moment, Senator Dibble, because I have a 19-year-old and a 16-year-old, a 19-year-old who was involved in an incident in his school where he was given the opportunity, and I have to tell you, Senator Nino, it did not go well. Unfortunately, for some situations, and this was about a girl, it was not about a bullying event, but it's complicated when we put 17, 18-year-olds to kind of face each other and try to figure out a solution. But I just was thinking about a situation involving 2 adolescents. But Senator Dibble and then Senator Clausen. Senator Dibble.
Thank you, Madam Chair. The goal of paragraph 6 that would be deleted is to allow young people who have either been the targets of bullying or have been bystanders, and they just want to be able to make adults aware that something's going on, so that adults can keep their eyes open and figure out for themselves. And that's important because sometimes young people see stuff. I mean, we heard some testimony earlier. People didn't come forward. Maybe because they feared reprisal, retaliation. Who knows? They felt like they had no power in the situation. I mean, there's 100 reasons. It's very complicated. So at least they can say, hey, you should be aware, responsible adult, that this is happening. Responsible adult can keep their eyes open, figure out what's going on. There's a protection, of course, because a solely anonymous report can't create some sort of response to the bullying incident. So that was important. That was an important finding, something we learned from the governor's, through the governor's task force as we went around the state and heard from lots and lots and lots of young people and their parents about some of the barriers that they came in, just systemic barriers that they came across or they encountered, which was the reality of their daily lives. the NENOW language that would replace paragraph 6 is kind of interjects kind of the adversarial, quasi-judicial court dynamic into this whole conversation. Keep in mind the underlying premise and value of the bill is not create all kinds of, a hammer response, zero tolerance, mandate some forms of discipline, and in fact, quite the opposite. It mandates a remedial response, a reparative, restorative response. And in fact, it's recognized that some of the traditional models of peer-to-peer conflict mediation resolution often cause greater harm and don't work in these particular circumstances. Remember, there's the imbalance of power circumstance that's present in a lot of the bullying, and it can exacerbate the situation and the circumstance. I'll leave it to the folks who Senator Dahl, Senator Clausen, others who are in the schools or have been in the schools as part of their professional lives on a daily basis. I think this, frankly, would cause a lot more problems and not solve any.
Senator Clausen.
Thank you. I think line 5.1, item number 6, really is self-explanatory. It allows anonymous reporting, but do not rely solely on an anonymous report. I think there's actually schools around the country that have anonymous reporting websites or call-ins for schools. And my experience as a principal has been you wouldn't automatically start an investigation necessarily, but you might alert adults who have contact with the student to kind of be on the alert about what's happening. Look for any kind of behavior that might require some investigation or discipline. So I really don't think the amendment is needed. An anonymous report would not automatically instigate an investigation, and I think your comment sometimes about bringing two people together without going out and getting witnesses and developing a case is what you would do here rather than just bring two people together and confront one another. So.
Thank you, Senator Clausen. Any other comments, members? On the 836 amendment, all of those in favor signify by saying aye.
Aye.
Those opposed say no.
No.
No. The amendment is not adopted. Members, do you have any other amendments? Thank you, members. So we have enough time for remarks from members. We have to leave the room at 8 p.m. Senator Dibble, I would like to hear some closing remarks if you would like to. I know you already.
Madam Chair, it's a good bill. You should vote for it.
Thank you. Thank you, Senator Dibble, and thank you to all of the people who've been working very hard. On behalf of our kids, I think that it is clear that we care very deeply about these issues. I am incredibly proud to hear really the concerns from different members and their attempts to make this a better bill. I think it was incredibly important, Senator Dibble, that we hear these amendments and that you hear the concerns that the members have. They, I think, are connecting with their constituents and their schools, and it is important that we recognize some of the challenges that we face for implementation, as well as some of the incredible opportunities that we have now to really respond to some serious concerns that are coming from our community. So I thank you for the patience and the time that you've spent. Senator Clausen, I know that you want to continue to work on this issue, and I do appreciate what you have done, and what you will continue to do, I'm sure, on issues related to this and other issues in the future. So thank you for taking the incredible amount of time that you've taken to help us get here and really make this policy much stronger than it was. So
Thank you, Madam Chair.
Thank you, Senator. Senator Nelson. Yes.
Thank you, Madam Chair. I want to thank Senator Torres Ray for allowing the time, I think, to more adequately discuss this bill. I think it's very evident, as you said, that all are very concerned about our children, want to make sure our schools are safe, our students are able to learn. And I think that's the goal of everyone here. We want to make sure that kids are able to achieve their maximum potential and become those leaders that we so need them to be. So I think this discussion was very helpful tonight. I greatly appreciate the time to discuss the bill. I also think that it was important that we as adults modeled that good civility, and I saw that tonight, and I think that's important as we go out of here, that we model civility and candidness and respect as we go forward. Now, regarding the bill tonight, at this point, I'm going to be a no vote on the bill, Senator Dibble, but I can see that you have addressed a lot of concerns that my constituents, and I'm talking about my schools, have had. Now, I was able to visit with one of my superintendents tonight, and he briefly said he did not support the, he was very interested in the local control and the fiscal note. And I think both of those have yet to be seen. So I'll be looking from Senator Uyghur's committee what the fiscal cost is on this, and also if local control is prevalent as opposed to top-down mandated control. And without having had the luxury of having this new amendment, the A32, in front of him, he could not give me a specific, although he was inclined to not support it until he had read further. All the other superintendents in my district were not in supportive, but again, they have not seen this amendment. So while I'll be voting no today, that this will allow me time to take the new amended language and really get it to our constituents, get it to the people in the field who actually do the work, and see if what is being proscribed here by us is in fact doable. Or is it a state mandate that is from St. Paul and not from the local control? And so that's what I'll be looking for going forward. I appreciate your patience and the work that you have done on the bill to this point.
Thank you, Senator Nelson. Okay, so
Madam Chair,
the number of Senator Dibble.
I just wanted to echo my thanks to Senator Clausen for his many, many hours and diligence as well. I meant to do that earlier, and I had failed to do so. And also serving as a translator and intermediary from time to time for me, with some of the stakeholder groups. It was excellent work, and we have a much, much better product.
Thank you, Senator.
Thank you, Senator. Senator Clausen. Comments? Okay.
I've said enough.
Okay, thank you. Thank you, Senator. So on the motion to move House File 826 be recommended to pass and re-refer to the Finance Committee, all of those in favor signify by saying aye.
Aye.
Aye. Those opposed say no.
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 The bill has passed. Thank you, Senator, and again.
Thank you, Madam Chair and members.
Thank you to the audience. And for now, we conclude the business of the committee, and the meeting is adjourned.